What does that mean to you?
Is that a question for me?
Yeah, solicitors.
Oh, sorry, man. I just sit back here and let you go.
Hold
and
on,
talk, and
Gavin's thumb's behind me.
Whew. Those brownies, man. You gotta be careful when you eat brownies.
Say it again, mate. Sorry.
Sorry, yeah. Right, liberties. Now, you've heard that term.
Hey folks, Gavin here again, and I'm joined by my man, he should be that way, Damian. So this is going to be the next video in a new series called Drivel to Civil. And the purpose of these series of videos is really just kind of, I guess, giving you, clarity, because there's a lot of noise out there. There's a lot of misdirection, unfortunately. There's a lot of misunderstanding as to what is what with regards to the law. So we're going to go through what the laws of England are, and this is going to be focused more on our rights, so how they protect our rights. So if we're looking into the constitutional statutes, obviously King Charles, and I say that, King Charles recently reaffirmed in his oath these statutes. So the Bill of Rights talks about customs, known laws, and statutes. So we're going to define, or Damien, I should say, is going to define exactly what these are. And we're going to discuss what the rights of the subjects are, we being the subjects of the monarchy. We're going to break down statutes and statutory legislation. So we're going to really just draw the curtains back here, and hopefully you're going to be able to use this video. You're going to be pausing it a lot and making your own notes, but hopefully draw the curtain back so we can really clarify once and for all what is law, what is statute, what is legislation, etc., and more importantly, what our rights are and how to use them. So with that said, Damien, welcome back, my friend.
Hi, yeah. How are we, Gavin?
I'm doing good, my man. I'm doing good. How are you? You've been busy though, haven't you?
Oh, it's like playing legal whack-a-mole. You knock one down, two more pop ups, bang, bang. You knock two more down with legal paperwork, four more pop up, and it's like, we spoke off there. I think we can do more good putting out our research, putting out our legal and lawful knowledge, and empowering others than constantly trying to, how can I define society at the moment? Society right now, and bearing in mind what I've learned to understand is I've been told to take a step back, and we can do more good, you and I, putting out the content we do, explaining, like in what we're going to do today, explaining our British jurisprudence, explaining the difference between our constitutional statutes, what they are, and statutory legislation. There is a difference, explaining the general customs, the known laws, the unwritten laws, what the common law is, how we get redress, and most importantly, our rights. People don't have an understanding of our rights, and there are three major rights we have. Well, there's a whole list. I'm going to go through that are protected in the known laws of England. And you might not get redress. Well, you certainly won't get any redress in the magistrates. It's an administrative court. You've got really no business being there, especially with what I'm seeing with regards to the council tax, and also now the use of section 444, part 1, subsection 1 and 8, where they're trying to enforce a fine and make it a criminal offence for a parent to take their child out of school. It's basically, they're circumnavigating due process of law and the rule of law, and that's what we're going to start with first, because you've got to get a basic understanding of what's what. There is the rule of law and an observance of the due process of law. Okay, we've got to understand where all this started, what the common law is, what protections we have? We have huge protections. They've just been hidden from you. And they have been put into learned men's writings through the ages. I've gone back as far as the 15th century with Sir William Lambarde, a common law jurist, a fantastic man of his time, Sir Edward Coke, Sir Matthew Hale, so the 16th century up to the 17th century, where in the commentaries of the laws of England, Sir William Blackstone, again, another incredible common law barrister and judge, they understood the common law. Now, the common law are the general customs and practices of the area, and England, laws going back to Anglo-Saxon times. Some have been written into statute, the constitutional statutes. You are not defined as a creature of statute when you use those constitutional statutes. They're there to protect the rights of the individuals, men, your natural rights and liberties, the rights of the subject. Yeah. And then you've got statutory legislation, which pertains to creatures of statute and mostly commercial enterprise. So it pays to understand and be able to define the terms of art they use, to define the terms they use. And when you get a basic understanding, I've gone through the interpretation section of the online safety bill because that's getting people very excited. But when you actually read what those, they tell you what the definitions are. So when you can interpret statute correctly, certainly there's statutory legislation, it pertains to persons, and they even tell you in there, includes a body politic, a body corporate and unincorporate, and associations. That is not the natural man or the individual protected. They're our rights. So if you're going to go along with their Mickey Mouse show and get dragged through the coals in a magistrate's court and identify as that, then you've got yourself a problem. And it talks again about a premises. And this is what I'm having with the utility company, where this top litigation paralegal, she cannot define the terms of art or the statute she's using. You know, and I'm just turning her inside out because she's having to do word gymnastics, you know, just to try and circumnavigate the truth. I'm coming from a foundation of truth. She's coming from a foundation of wordsmithery and a foundation of sand. You know, you could take that into biblical terms. You know, do you put your house on sand? Do you put your house on rock? You know, well, the rock is the truth, and the sand, the foundation sand, is a deceit, lies. And that, unfortunately, they've been taught these deceitful legal practices. They don't understand the laws. They don't understand personal liberties and rights, and your inviolable property rights. I mean, they're so protected. And she thinks that as a statutory undertaker, that gives her the legal right, duty, and obligation to circumnavigate my property rights and private personal rights, which it doesn't. And when I've correctly defined the terms of art she's using, a premises being a business, and I can prove that I'm not conducting any business from my private property, she's had to do mental gymnastics and come back to a premises actually means a private dwelling, when I've already proved that a premises is a business setting. And I've done that with case law. I've done that with Oxford and Cambridge dictionary definitions. You know, it's unarguable, but they do mental gymnastics to get around where it's a private dwelling. Okay, well, a private dwelling, according to Lord Sumption, is a hereditament, you know, which if you then define that in the Local Government Finance Act, it's real property, which is real estate, which again, we come back to commerce. So we go round this merry-go-round. You know, sorry, love, it's commercial. You can't interpret your own act. You think the Water Industry Act 1991 gives you the right to do what you're doing. It doesn't. And your statutory world does not supersede, this statutory legislation does not supersede primary legislation, constitutional law. But what they've been taught, and if you buy the legal constitutional books, that will come into tier 3, which is constitutional and administrative. So you've got the hierarchy of law, constitutional law, protecting the rights of the individual, the subject, natural man. Boom. Statutory legislation. So stop thinking when you use a constitutional statute that makes you a creature of statute. It doesn't define the terms in that statute. This is why it's important to read Scalia and Garner, the interpretation of legal text, which we did in the previous video. So you can define the terms of art they use and understand that applies to me, that doesn't. And this is how, this is why. Yes? I mean, surely that I can't put it any simpler. So constitutional law protects our rights and it doesn't make you a creature of statute. This here, I've gone to tier 2 when we went to family court. And because my son put in a statutory child arrangements order, which we were there to protect that and stop the opposing solicitor from having it thrown out of court, I was in the statutory realm. I had to draft an order to protect that order, okay, because my son had defined himself as a creature of statute, a parent, and the child, okay? But I read the statutory legislation that had the common law written in and was able to pull it out and then back that, because this is the other thing. The common law was written into those statutes. You got the unwritten laws and the written laws, okay? The statutes and unwritten laws before the time of memory, which is Richard I, 1189, and the time from memory, which we're going to go into. I read the Children Act 1989 back to front, the Family Law Act 1996 back to front, found the common law. I got case law ruling, Supreme Court ruling, showing where the common law was in that. And then for the outcome was able, because the common law, you've got 2 remedies of redress. When the common law is present, you can use a common law remedy, which is a very narrow. If you type in Google common law remedies or common law redress, which have been around since time immemorial, and been passed down through the years, through the ages, it's very narrow in its application, whether that be in contract. Most contract law is from the common, and the redress grievances in that. But if you take it into equity, it's got a much bigger application for redress. You understand that, Gavin, because you're very au fait with equity. And I was able to take, because we'd pulled the common law out of that statute in my draft order, and then took it into equity. And I was able to then put in take apart previous deficiencies in the opposing party where there was a non-molestation order catalogued, which had been unlawfully granted. How? They hadn't followed due process of law. And this is what we're going to talk about shortly. Due process of law and our statutory rights protected in the Human Rights Act, because they hadn't observed the due process of law. They hadn't followed due process. That got thrown out. They weren't able to bring that up and besmirch my son's character because it was unlawfully granted. They hadn't followed due process. And he hadn't done anything wrong anyway, because these things are being used as a weapon. Oh, we've split up. Oh, I don't like you anymore. Oh, I can't get a reaction out of you. Right, I'm going to get a non-molestation order. You're harassing me. Oh, no, you're harassing me. You keep texting me. I ignore you. But that was the situation. So, and the other thing was some historic charges. She'd and how she was lucky she wasn't, we could have pursued the fact that, she was wasting court time in the respect that these were false allegations and that we simply got a police report saying, well, they never charged. If the police have found no evidence to pursue this, these allegations are just an opinion. It's hearsay. And there are rules of hearsay and rules of evidence. So they had to throw that out as well. And my son has marched on with his child arrangements order. He said after, well, that went really well. I said, well, you've won. I said, the whole purpose of that hearing, right, for the opposing side was for their solicitor to get that child arrangements order that you put in place thrown out. It didn't happen. And all the historical nonsense was thrown out too. So yes,
facts of law matter, right? And also, I think in that case as well, that hearing you fired a shot across the bow, didn't you, against the court agents to just let them know to behave.
yes, yeah. Look, guys, you've got a player here. You've got somebody that understands and observes the rule of law, and you guys with this draft order, you're on notice because we know how this works. Okay, we've become learned. We're not part of your system. We're not a registered court officer. Sorry, we're more dangerous because we are now not subservient to your court. We are practicing the rule of law, and we know how to do this, and we're going to do this.
On that note,
Is that a fair deal? The magistrates treated him with so much respect, and we got the outcome.
But only because you demonstrated with your paperwork and then in person that you knew the law, you understood the game, and they knew that you understood the game, and therefore they behaved and they followed the due process of law. And I think it's probably a nice segue actually into that, isn't it? So let's take that now and let's talk about the observance of the due process of law, which is a statute, by the way, and I will provide a link to that in the description.
Yes.
So yeah, with that said, let's go into that because this is really where it all starts. And you'll find that when you're challenging these different agents, they don't follow it. So there you go.
They don't follow their own rules, which is why they're, once you understand the rules of the game, it's very simple to just take apart. I would say two things. It's observance of the rule of law and understanding that everything our public servants do, and they are public servants because they take monies from the public purse, which means two things. They're accountable and they're liable. Okay. And the beauty is, again, you bring the common law into this when you've been harmed and it caused you an injury and economic loss. You can bring the common law doctrine of respondeat superior, which the Latin definition of that is the master shall answer. Okay. It's vicarious liability. So the employer is responsible for the actions of the employee in the duties of their employment. So everything is a breach of duty, or it's a breach of contract, or as Professor Albert Venn Dicey states, the top constitutional lawyer, judge of his time, that all the law lords, i.e. our House of Lords, who are the check and balance against a tyrannical government, the Supreme Court, the Court of Appeal, the High Court, they understand, these judges understand, and they will reference Professor Albert Venn Dicey, a breach of the rule of law. So what if they breach the rule of law? Then they breach their duty. They have a public duty. You've got a cause of action if they've then damaged you. So you just decide what that cause of action is and go after them and get the remedy, the redress in common law, equity, with injunctive relief, get a judgment. So observance of due process of law. Now, bear it in mind, this is important. You've got the common law, which is general customs and practices. That's what that is, the common law. So when they say I think it's the Act of Settlement, which is, to me, look, call it a constitutional statute. You could call it a common law statute because your rights, your liberties, your protection of properties are written into those statutes. Okay? The rights of the individual. Right? So call it a common law statute because a lot of the common law was written into statutes. Okay, so you get redress. And using a constitutional stroke common law statute does not make you a creature of statute. You know, I mean, you identify as a natural man, as an individual, and a subject. You know, there has to be an agreement. There has to be an agreement as being part of society. Okay. We understand the government is set up to protect your rights and properties. Okay. Well, the checks and balances are these constitutional statutes. Common law has been written into a lot of these statutes. Lex scripta, lex non scripta, which is written rules, the written laws, the unwritten laws. And we'll get into that in a minute. So, observance of due process of law 1368, which says that no man be put to answer without presentment before justices. Matter of record. So, in front of a justice, a court of record. Okay. By due process and writ original. Okay. And you can use common law writs. Again, Google common law writs, common law remedies, common law doctrines. You know, two of my favorite doctrines are that respondeat superior. This is what I use against counsel. Okay. Well, you know, think about the traffic warden that tried to violate my property rights, i.e., by trespassing on my car. It's my property. I have inviolable property rights. Well, I didn't just go after him. I went after the CEO that he worked for at the council. And guess what? The fine went away. I haven't heard anything. I hid in the hair of him for 3.5 months. And in fact, I bumped into the traffic warden the other day and had a chat with him. You know, he just so I have a laugh with these people. I said to him, I said, you do know they never pursued that fine. And I said, I still see you breaking the known laws of this land. You put a ticket on someone's car. I said, you're in big trouble, mate. I said, just remember to keep away from this car. It just jumped off. Oh dear. But yeah, with regards to the common law,
Can I just actually just to come in there because there
Yeah.
might be some people that this is the first video they've seen of you talking about this stuff and you know the common law and everything else. So just clarify for the folks watching again, what is the common law?
the common law are the general customs dating back to the time before memory, which we're going to go into, and the time after memory. Okay. And a lot of the common law has been put into statute. Okay. Whether people want to hear that or not. But then there's two types of statutes. There's those constitutional common law statutes that are protecting the rights of the subject, the individual, man. Okay. Look, man was written into this. This is a constitutional statute. Now, you can go back to the original common law statutes, the Magna Charta, not Carta, Magna Charta and Charta de Foresta. Okay. And then the Nova Statuta. Okay. And this is a whole list of statutes from the 13th century that are held in the Chancery Roll, and the Tower of London. Okay. They're all common law constitutional statutes for us. So just a little bit of researching, a little bit of reading I've done. And I've cross-referenced with 5 or 6 different eminent law scholars from the 15th, 16th, and 17th century that the law lords in their Supreme Court rulings use. Okay? So the common law is unwritten and written. Some of it's been written into those common law constitutional statutes. Tier 1 of the hierarchy of law. Tier 2, statutory legislation, acts of parliament. Okay? Most are commercial. Tier 3, administrative law. which is more local government functions, magistrates court, etc. 4, case law, common law. The case law, which are the judgments and precedents and rulings, but you've also got the common law in tier 1, so tier 4 and tier 1. Yeah. The known laws, because it's lex scripta, written laws. And then we've got the unwritten, lex non scripta. We'll get into that. So I'm going to do a big thing on the common law here. Right. So we've got here that no man be put to answer without present for the justices as a matter of record, which means on court record, and by due process and writ original, according to the old law of the land. Those are the known laws, which we're going to get into. They protect your rights, but that will be done shortly. Now, if anything be done to the contrary, i.e., against those, it shall be void in the law. Okay, that's it. Now, going on due process, the first recorded written reference to due process is in the Liberty of the Subject, 1354, which is part of the Nova Statuta, which incorporates the Magna Charta, the Forester Charter, and all those ancient statutes that still have the force of law today. Okay? One of those. This is important because it's to do with our rights. Right. None shall be confined without due process of law, that no man of what estate or condition shall be put out of land or tenements, or taken, nor imprisoned, nor disinherited, nor put to death without being brought into answer by due process of the law. That was in 1354. Okay? That still has the force of law today. That's on the statute books with no changes. You can check that. So what we've got to do is really define the terms that we use, and we'll get into that. Now, the guarantee of due process of law is the limitation is only on the state, the powers of the state. That's what the due process is there to do. It's to limit the powers of the state. Yes? And protect our life, liberties, spiritual, which is our religious beliefs, our customs, temporal, which is worldly, customs and practices, which is the common law, and civil rights. Defined what the civil rights were, because they're in the Coronation Oath Act, another common law, constitutional statute, civil, relating to private rights. People are on about bloody private all the time without actually knowing how to define private or protect your privacy. What you would redress as your private rights in a civil action. And how would you do that? Using the rules of civil procedure through the courts, which people are frightened to do because they think for some strange reason that if they associate with their all caps name, they've created some kind of joinder and therefore some imaginary jurisdiction over themselves, which is complete horseshit. Okay. So that name is yours, right? Use it to get civil redress, what is civil, relating to private rights and remedies sought by civil actions. Okay. Right. So, liberty, which is your rights, can only be invoked by those with life. Think about, what does that mean to you?
Is that a question for me?
Yeah, it's awesome.
Oh, sorry, man. I just sit back here and let you go.
Hold on, Gavin's thumbs behind me.
Whew. Those brownies, man. You got to be careful when you eat brownies.
Say it again, mate. Sorry.
Sorry, yeah. Right. Liberties. Now, you've heard that term. That's protected and constant. See, I made you laugh. So, guys, this is what this is all about. It's it's giving you guys important information in a very relaxed setting. Gavin and I are mates, right? Become mates in our own spiritual and lawful journey. We've met on this journey, okay, and become good friends. So we're going to have a laugh. Right. Liberty. Now, your rights, the customs, the known laws, statutes we know about are protected in these constitutional statutes. We're going to go into that because that's three things: customs, known laws, and statutes. Well, that's three different things. So we'll get into that, but also your rights, properties, liberties. Liberty is also rights, and liberty can only be invoked by those with life. What does that mean? Who's got life? Liberty can only be invoked by those with life. Who are those?
Us.
You got it. It's that simple. So if you know me, you're looking for a complex answer. You don't have to give me a complex answer. I'm all about breaking things down to its simplest terms. So only we can invoke liberty, right? Creatures of statute, corporations have no life in them, therefore no standing.
Correct.
That's it. Now, rights are fundamental, a foundation. What it is, fundamental is a foundation, okay? Men and women have rights, corporations do not, okay? Constitutional law is due process substantive. The substantive means your rights have come from God. And so William Blackstone is very clear about that it's come from God, your creator. And he defines that brilliantly, your natural rights. So your natural rights are written into these statutes. Okay? So let's have a look. Your due process substantive rights are recognized in our constitutional statutes. Fundamental rights are protected by substantive due process. Common law rights are protected in procedural due process. Okay? Right. What is due process? That's the million-dollar question, isn't it? Due process deals with the correct and lawful administration of justice. I'll say that again. What is due process? Due process deals with the correct and lawful administration of justice and acts as a safeguard from denial of life, liberty, or property by the government or agencies thereof, corporation, offending parties, individuals. So it's there for us, isn't it?
Very clearly there for us, yeah. Which is,
So
it's everything. It's pretty obvious why they kind of bury it and hide it, and they don't teach this stuff at law school anymore.
you've got it. And this is what I'm finding. When you start to box with these people in legal terms, you understand that they've come from a place of no foundation, no fundamental understanding of constitutional law and due process.
It's actually that they are the very creatures of statute, because that's all they've been trained to do and use. And it's
got it.
one of the things I've just speaking for me personally, it's like when you go head to head or toe to toe with these individuals, if you know this stuff, you've got a massive advantage over them because they really don't know.
They don't. Yeah, half you think, some of the responses I've had back, I think, surely you told me this, stupid, or you're pulling my leg, or, you actually can believe this stuff. It's like, but you realize that they are completely indoctrinated.
Yeah.
They're no different. Look at the other side of it. So you're dealing with these so-called legal experts that are completely indoctrinated and have been steered as far away from the constitutional statutes of common law as could possibly be. And they're put in this legislative paradigm, but they're no different to the same knuckleheads that would be over here that are still doing UCC filings and live life claims and and claiming to speak a quantum language that the courts and nobody else understands under the banner of being a postal federal judge, or a plenipotentiary judge. It's absurd. But the rules of due process have been put in place, and they've been there for 1,000 odd years. And I've gone back and I can source, these are the rules that the law lords use and that they have to use. Forget the magistrates' court. I believe now that is completely been corrupted and circumnavigated. It's become almost just a private bar guild, private tribunal, and a ways of printing money.
Absolutely is. We obviously have running tools, but they're so corrupted. It's so, they're not lawful anyway, are they? We all know that anyway, but
Yes.
talk about don't follow the due process of law.
They don't.
There's nothing on the record. They're getting away with everything that they do. And this is to Damian's point and what we keep talking about. They're public servants. They're liable. Hold their feet to the fire to get your remedy.
Yes. There's the laws of remedy, and there's the law of tort, and that's there to get you redress. So, due process of law is a constitutional guarantee that prevents government from impacting citizens in an abusive way, right? In its modern form, due process includes both procedural standards that court must uphold, which is why we have to circumnavigate the magistrates' court. Now, I got redress because they do function in the family side of that court. And I've had two very good experiences in 1 month, and that was during the period of August. The family courts do function, but you have to show them that you understand due process. And that's what we got a very positive experience. Now, on that, I'm going to say it again. In its modern form, due process includes both procedural standards that courts must uphold. I'll put a footnote here in my notes. Think councils in league with magistrates' court. Are they acting in accordance with due process? That's for you, but you've already answered it. And you're on mute.
Sorry, muted again. No, is the answer to that.
So, this is important. In order to protect people's personal liberty and liberty interests, which you're right, statutes and regulations must not infringe. And they're on about statutory legislation and regulations. So we're being told, and the law scholars are telling us, and you can put this in your writings, your pleadings, your complaints, that hang on, you're saying that this says you can do that, but that's a rule out of statutory legislation that you haven't defined correctly. You're using terms of art you cannot define. I can interpret this statute, it's commercial. And besides, it says here, this eminent law scholar and this case law says that statute and regulation must not infringe on my personal liberty and liberty interests. Well, you're infringing on my private rights and my property rights. And we'll get into that a bit later. So we've gone into the first instance of due process of law appearing in 1354. So it's been around a long time, nearly 700 years. So we've then got that is part then of lex scriptura, which is the written laws, and where the common law has been written into statute. Okay? Right. Sorry, I've got a bloody load of notes here. Then there is lex non scriptura, which are those general customs we know to be as the common law. Okay, so we've got some of the common laws being written into the statutes, the ones that protect our rights and liberties and properties. And then we've got the general customs known as common law, those laws and customs applicable to certain courts, which is where you'll get your address in the High Court, the Court of Appeal, the Supreme Court, because they understand that. Those customs derive from natural law, ancient usage and customs unwritten. So then you're going back pre-Magna Charta, you're right the way back to the Anglo-Saxon laws, which even the Romans respected, okay, and allowed to continue and flourish. They just Justinian sort of civil law, yeah, right. So those laws of England not written into acts of Parliament, instead comprised under, this is really important, this is where we get a case law, under record of pleas, this is common law, record of pleas, judicial decisions, proceedings and judgments, and my favorite that I use all the time, law scholars, arguments and opinions. And I use that because our law lords use that in their Supreme Court rulings. So if you've got beef in the county court, you go, well, hang on, Lord Hodge or Lord Sumption or Lady Howe said this in the Supreme Court and ruled for it. So you can't deny that down in this inferior lower court. They're not going to go against it, are they?
Again,
So-
you've got to remember there, if you like, they're all public servants, they're all liable.
So they're not going to go against it because they understand. You made very clear that you understand the rules of the game. You know, how are they going to go against the Chief Justice? They're not. And the Supreme Court, because if you then appeal their decision because they've gone against it and you've kicked that up to the Court of Appeal, once one of those law lords gets hold of it, I mean, they're probably going to end up getting disbarred, that particular district judge. So, yeah, you've got to see that every action has a reaction or a consequence.
Absolutely.
So there's more common law there, record of pleas, judicial decisions, proceedings and judgments, and law scholars' arguments and opinions, all preserved from ancient times. So a lot of the ancient common law has been written into statutes, lex scripta. Think anything to do with individual rights, liberties, and properties. Look at the Magna Charta, the Charta de Foresta, and then the later statutes, Bill of Rights, the Coronation Oath Act, 1688, and the Act of Settlement, which clearly defines the subjects, the people's and the subjects' rights. It could be argued that the Magna Charta's guarantees originally applied only to those at the top of the social hierarchy at that time. But then our rights were further redressed in the liberty of subject and observance of due process of law, which is why I thought these two particular statutes that are still on the statute books and have the force of law, I brought those on today. Don't want to upset anybody from the Magna Charta world, and it is the Magna Charta. Sorry. I've got Sir Matthew Hale, Sir William Blackstone, Sir Edward Coke, and a few others backing me on that. Let's you argue with them. Oh, sorry, no, they're dead. Right. With the common law, I reference firstly Sir Matthew Hale, 1609 to 76, a top common law judge and jurist of his time, cross-reference with Sir William Blackstone and his commentaries of the laws of England, published in 1765. And another expert on the common law, also Sir Edward Coke, whom they both reference. There's like a triple reference. And I even then went back as far as William Lombard, the 15th century, and a top barrister and common law judge. And Sir Edward Coke, wonderful people. I advise you start Googling, start reading up on him. He was instrumental in the creation of the Petition of Rights, 1627, which really limited the king's power and prerogative at that time. He was really for the people. A wonderful man. He was a champion of the rule of law, declaring the king to be subject to the common law, not above it. This is where you learn.
That's pretty powerful, that statement and that fact there, what you've just said.
Yes.
Very
And
powerful.
this is why I call him our highest ranking public servant.
Which is the truth, right?
Yes.
Which is where I think we're on the same page. The coronation oath for me is the preeminent statute of statutes. It's kind of right at the very top. Everything comes from it.
I think just that statute, you can get all your grievances and redress
Yes.
just on that.
I agree,
I mean-
especially when you're dealing with courts, given that they have to swear their own oaths, right?
Yes. So the courts are all under His Majesty.
Do you find the legal system overwhelming and wish you had the knowledge and skill sets to control judges, persuade attorneys, and win your case? Well, look no further. Sovereign Empowerment is proud to announce our partnership with Dr. Frederick Graves so that we can bring you the Jurisdictionary Law course, How to Win in Court, your ultimate resource for mastering the courtroom. Unlock powerful case-winning strategies as you learn to control judges like never before. This comprehensive course eliminates guesswork and empowers you to navigate the legal landscape with absolute confidence. With step-by-step instructions, flowcharts, and outlines, you'll have all the tools you need to persuade and control judges in any case or court. Learn from a seasoned attorney with over 40 years of winning experience, who has distilled his expertise into this comprehensive program. Access everything you need in one single package, including sample forms, video seminars, audio clips, and in-depth case-winning classes. Learn at your own pace, anytime, anywhere. Our 24/7 online access allows you to tailor your learning experience to fit your schedule. Access the course on your smartphone, tablet, or computer and become a legal master whenever and wherever you want. Benefit from a suite of powerful tools, including a free online legal research tool, a legal dictionary with common sense definitions, and an exclusive Q&A forum to connect with fellow students and obtain expert guidance. Good people have suffered too long at the hands of power because they just didn't know how to fight back. Now, in a matter of just a few days, you can acquire the tools and knowledge that takes law students years to achieve. Can't afford a lawyer? No problem. With the Jurisdictionary Law course, you'll gain the skills to win your case without expensive legal representation. Alternatively, equip your own legal consult with the tools and tactics to fight effectively on your behalf. Level the playing field and secure your victory. No matter what court, civil or criminal, conquer any courtroom challenge with ease. This step-by-step guidance ensures a quick and straightforward learning experience, empowering you to navigate the legal system with bulletproof confidence. As a testament to your newfound legal expertise, you'll have the opportunity to complete a final exam and receive an honorary law degree upon successful completion of the course. Showcase your achievement and establish yourself as a force to be reckoned with in the legal arena. Dr. Graves believes everyone deserves access to legal knowledge. That's why we offer the Jurisdictionary Law course at an unbeatable price. For less than the cost of a 1-hour legal consultation, you'll gain unlimited access to this complete program for up to 2 full years. Take control of your legal battles without breaking the bank. How to Win in Court has become the most trusted law course worldwide since 1997. Don't miss out on this exclusive opportunity to gain the upper hand in the courtroom. Enroll in the official Jurisdictionary Law course today and unleash your legal power. Click the link in the description below to become legally empowered today.